Hello, this is Attorney Doug Jones. I wanted to take a minute today and talk to you about powers of attorney. In Arkansas, there's two sets of law that governs powers of attorney. One that governs property or financial powers of attorney, and then one governs healthcare powers of attorney. Normally we see these two powers of attorney merged into one document, but better practice seems to be to split them into two separate documents, because one governs one set of issues, property or financial matters, and the other governs healthcare matters, which is a totally separate issue. Property powers of attorney are critical to have. If you lose capacity and you have no powers of attorney in place, oftentimes the result is your kids or spouse has to petition the court to be appointed as your guardian, which in effect removes all rights, all power from you, and gives it to someone else, your spouse or your kids. That's usually not a good result, and it's expensive and burdensome and time consuming, and they're dealing with a court. All of this could have been resolved by having a proper power of attorney that says who you want to handle your assets if you become incapacitated, and you even name a backup to that person. So it's a great thing to have. You know, most of the time, if people do any estate planning at all, they may have a will, but they don't give much thought to what happens if I become incapacitated before I die. Yet we know a lot of people become incapacitated before they die. In my book, a power of attorney is one of the most effective documents, if done correctly, and one of the most important documents you can have. Now, we also mentioned healthcare power of attorney, separate document that governs who you would want making healthcare decisions for you in the event you're incapacitated and you couldn't make them yourself. Not many things in life is more important than that. If you get sick, if you have a stroke, or something bad happens, you want to nail that down. You want to have in place who you want making health care decisions for you. You want to have had a conversation with that person before the time happens, and you want to say in there what you want to happen in the way of health care decision making and what you don't want to happen. Now, a healthcare power of attorney is not to be confused with a private living will, which sometimes I refer to as pull the plug document. A private living will says if I'm incurable or irreversible or terminally or permanently unconscious, then the attending physician may decide to withhold or withdraw treatments that only prolongs the process of dying and is not necessary to your comfort or to alleviate pain. That's critical to have. But in our private living wills, we also say that, but if I have named a healthcare proxy or a person under a healthcare power of attorney, that person is the one I want making healthcare decisions for me. We do this for a couple of reasons. Number one, most doctors don't want to be put in a position of having to make a life or death decision for you. Secondly, it's critical for you to name a person who you want making healthcare decisions for you. And if you've got the power of attorney tied to the living will, well, then you know what that decision is going to be, and you know who's going to be making it for you. Another closely related document is a HIPAA authorization. A few years back, Congress passed the Health Insurance Portability and Accountability Act, which is the portion that relates to this is the privacy sections that in effect say unless you have authorized a person in writing to be able to receive or be authorized to receive protected health care information on your behalf, well, then they can't get it. And so it's critical to have that in writing. If you go into the hospital for a voluntary procedure, you can sign a HIPAA authorization on the spot. But if you go into the hospital on a stretcher, you can't sign anything. So it's important to have that in place. These are a few what we call ancillary documents that we prepare usually incident to or in addition to a proper estate plan, a will-based estate plan or a trust-based estate plan. Critical to have these documents in place. They're very, very important, again, because they affect what happens to you while you're still here on earth, before you die. So that's critically important. If we can assist you with this process or provide more information to you, just give us a call and we'll be happy to visit with you soon. Thanks. Talk to you later. Bye-bye.